Yeah. Consideration and possible action to be taken by the town board about the determination announced under Title IV of the town ordinances with respect to the MRED Cummings pertaining to the hours of operation for its approved Walgreens. Supervisor Bansky, you asked to have this put on the agenda. When did you give MRED notice that this was on the agenda?
I'm not required to.
Hold on, Mr. Bansky. You are required to. Under section 13-4-2, I believe, you're required to give, the town is required to give notice to a petitioner if their if action is going to be made, taken, potential action taken.
Can you show me this ordinance, please? This language?
Check on 13-2-4 sub I.
What does it say?
Look it up. Do you have a book? Do we have the code book here? 13-2-4 sub I. So 13-2-4 sub I. I'm going from memory. Yes.
Modifying and/or termination of site plan or plan of operation. If any of the site plan or plan of operation does not continue in conformance with the approved plan or operation, the use and site plan approval may be modified and/or terminated by the action of the board. Notwithstanding the foregoing, prior to any decision made by the town board, which will result in the modification and/or termination of the use and site plans as previously approved. The property owners shall be given written notice of the proposed action to be taken by the town board and shall be afforded an opportunity to present evidence and be heard by the town board prior to any final action being taken by the town board which could result in the modifications or termination of the use and site plan.
Well, that would be appropriate if I was in any way modifying, altering, or changing their site plan. Their site plan was approved on July 22nd, 2013, and I'm not making any modification or any change or alteration to their site plan. I have read to this board 2 weeks ago a resolution that states, I'll spare the Lord a reread of it unless you want it, chapter and verse of the facts that were provided to this board through a series of meeting minutes and through the legal analysis opinion from Attorney William Deneen, and a resolution that provided that the Title IV review was unlawful and did not have standing, and that the approval that was done on July 22nd is the valid approval. And I'm not seeking to modify that, not one little bit, so they're not required to have notice of anything. Until, if this gets passed, then this resolution instructs that we, if this is approved, that the town board instructs that a copy of this resolution be mailed to Mark Lake and Robert Flanagan, the appointee that did the review.
Mr. Bansky, regardless of whether or not you agree with whether or not Title IV applies, the petitioner asked for a Title IV review, not Chairman Merritt. The petitioner asked for it. It was done. Mr. Flanagan was appointed to do the review. He completed the review. He disagreed with the board's administrative decision, and that's where it stands.
It doesn't stand there.
you had an option to go to the circuit court. Your redress for this issue, the town's redress, is to go to the circuit court in Waukesha County for writ of certiorari. You declined to do that.
It's not true. That's not our
If we
redress.
take action on this at this time, we are gonna be denying the due process in the ordinances that have been set up in the town of Waukesha and set the town up for yet more litigation.
Just like you did with the accountants, John.
No, sir, because everything that in that accountants, everything in that is factual, Joe, and nobody has disputed that.
Okay, here's a fact. Whereas the number of days expired from July 11th through September 6th was 57 days. The right for them to exercise any described right under Title IV was 30 days. Title IV was an unlawful use.
That's unlawful.
It was an unlawful use, and Attorney Deneen sat right there and agreed with that statement.
No, sir, he
Yes,
did
he
not
did.
agree with unlawful.
Yes, he did, and you can listen to the recording. So I again make my motion that, and I would be happy to read, copy print for anybody, the 3 pages of whereases.
No, that won't be necessary, Mr.
And I make a
Bansky.
motion to approve and send this resolution forward.
Attorney De La Mora, this motion failed at the last meeting of this board. Mr. Bansky was not the prevailing party. Could you please go on record as to the ability for this to be reconsidered by somebody who was not in the prevailing party?
Thank you very much, Mr. Mayor. And thank you for giving me the opportunity to research the situation here.
I didn't give you an opportunity to research it, and if you're asking that. I disagree. The board did not give you authority to research that, so please don't send us a bill.
Mr. Bansky was present at the last meeting and made a motion, and the result of that motion to approve that resolution was a tie vote. At the last meeting of the town board, which was attended by 4 supervisors in person and by Supervisor Alaska by Skype, a motion was made to take certain action as you have been discussing. Although the electronic connection facilitating Mr. Alaska's participation was operating at the time that the meeting was convened, it failed, and Mr. Alaska did not participate in the taking of the vote. There was no discussion as to what caused or when Mr. Alaska's electronic presence at that meeting ceased. Following a 2-2 vote on the motion which he had made, Supervisor Bansky made a motion for reconsideration. There was an objection on the grounds that Mr. Bansky was not eligible to make the motion. Because of the peculiar circumstances at hand, as I've indicated a moment ago, I indicated that I felt it best if I provided a written opinion, which I have copies of for you if you would like. The Town of Waukesha Ordinance 2-3-13C provides, except as provided below, the town board shall, in all other respects, determine the rules of its procedure, which may be governed by Robert's Rules of Order, copyright 1992, which is hereby incorporated by reference unless otherwise provided by ordinance or statute, except when otherwise limited or modified by this code of ordinances. A motion to reconsider can only be made by a member, quote, who voted with the prevailing side. In other words, a reconsideration can be moved only by one who voted aye if the motion involved was adopted, or no if the motion lost. And I give the cites to the Robert's Rules, which I'll spare everyone. A motion to reconsider must be second at the time it is made. Unlike the making of the motion, which must be done by a person who voted with the prevailing side, the seconding can be done by any member regardless of how he voted on the motion to be reconsidered. And again, I give the cites. The placing of an item on the agenda is controlled by Town of Waukesha Ordinances, Section 2-3-11, Pram B, Pram 2, and can be done by any person who follows the procedure indicated regardless of whether that individual was a member of the prevailing side of a motion sought to be reconsidered.
I'm sorry, can you read that back, please? Can you read that back? The
Yeah.
Section?
Yeah, the placing, the specific 2-3-11, Pram B, Pram 2. Okay. Were you able to take that down?
11B2?
Yes, sir.
Okay, go ahead.
A motion for reconsideration is debatable if the motion to be reconsidered is debatable, cannot be amended, and requires a majority vote for adoption. And again, I have the cites from Robert's Rules. If it is reasonable to conclude that Supervisor Alaska was not, quote, present, end quote, for the vote on the motion through no fault on his part, it is possible for him to make the motion for reconsideration on the basis of the following language found in Robert's Rules. Quote, in standing committees, parenthetically, which the town board is, the motion to reconsider can be made by any member who did not vote on the losing side, including one who did not vote at all. Robert's Rules citation.
That's for the second, is that correct?
No, that's for making the motion.
Okay.
Finally, it should be kept in mind that the Town of Waukesha Ordinance Section 2-3-19 provides suspension of rules. Any of the provisions of Section 2-3-13 through 2-3-16, inclusive of this code, may be suspended temporarily by a majority of the board members present at any meeting. The town's rule on the reconsideration of questions is contained in Section 2-3-16. Putting it very simply, Mr. Bansky is not in a position to make the motion for reconsideration. There really are only 3 people that can make that motion. Mr. Alaska, Mr. Fisher, and yourself. Anyone on the board can make the motion to second the motion for reconsideration. And the motion for reconsideration passes or fails on a majority vote.
Okay, thank you. I want one last question for you
Yes, sir.
before we take action on this. Is it your opinion then that we would not be violating the due process of the petitioner by having first not having had him here, and secondly, not following the town ordinances regarding Title IV with this issue?
I believe that the logical explanation provided by Mr. Bansky and the posture of the matter that was pending before the board is such that at this point in time, there is no implication of any due process rights of any applicant that had come before the board.
Thank you. Mr. Bansky?
Due to restrictions that we have as supervisors to talk with vendors such as Attorney De La Mora, I reached out to Lee Taroni, the Towns Association attorney. My question surrounds a resolution that appeared on a prior agenda 2 weeks ago. There were 4 members of a 5-person board available to vote. Result of vote was 2 yea, 2 nay. Again, 2 supervisors voted in favor. 1 supervisor and town chairman voted against. The other supervisor was not present and did not participate in the vote. Can I bring this back? Joe, tie votes result in the action failing for lack of achieving a majority. There is no statutory limit on how many times the same thing may be brought up on future meeting agendas. My motion was not to reconsider the vote that was taken. My motion was to submit the resolution for consideration and discussion by the board.
Fair enough.
Jamie,
Any further-
you can have that as.
Any further conversation on this issue, Mr. Fisher?
I have a question for Attorney Dale Moore, just for your opinion then. Your interpretation on your email there, the second last paragraph on the bottom, it says, in standing committees, the motion to reconsider can be made by a member who did not vote on the losing side, including one who did not vote at all. Is it your legal opinion then if somebody simply is absent and does not attend the meeting, then when they come and attend at the next meeting, they can bring a motion to reconsider? Is that your opinion?
Part of the reason why I basically asked for timeout the last time was that the whole purpose of Robert's rules is to allow everyone to have a voice in the outcome of a decision of a body that he or she may be a member of. And you will note that earlier in my comments here, I indicated that if it was assumed that Mr. Alaska's inability to participate and vote was not of his own doing, that would be a legitimate basis for considering, in my opinion, the fairness of the situation to allow him to make such a motion. It's a peculiar provision in Robert's rules. I wanted to make sure that I had it right, and I do believe that if there's a bona fide reason for the individual being absent and there is a tie vote, Robert's rule does allow that individual to bring the matter forward on a reconsideration.
My question was a little bit simpler, has nothing to do with Mr. Alaska, but a bigger principle. If someone simply is not at a meeting, yes or no, can they bring it up for reconsideration?
Mr. Fisher, I know that you work in a universe which is
It's a simple
reduced to
question.
numbers, which in your mind can be answered in a binary fashion. But the reality is that case law and statutes are interpreted not in the abstract, but in the context of specific facts. And for that reason, I've taken pain to clarify the facts here. I can't give you a binary yes or no answer.
Thank you.
Anything further on this issue? Roll call vote, please.
Let's repeat the motion.
If you want to read all that.
You don't want to do that.
You better go there.
I just want clarification for the adoption or in the last
For the
minute.
adoption of this.
For the adoption of that.
Supervisor Wolf,
Yes.
Supervisor Laska,
Yes.
Supervisor Fisher,
No.
Supervisor Bansky,
Yes.
Chairman Merrick.
No.
Motion approved.
L, consideration and possible. It's okay. Consideration and possible action be taken on the town board regarding the outstanding invoice payable to Clifton, Larson, Allen dated 9/30/13. What do you want to do, Mr. Bansky? This is your request.
I would pose a question first to Mr. Fisher. You had asked 6-7 weeks ago for this item to be tabled to obtain clarification. Has clarification been provided to you that's satisfactory to your inquiry?
I think there's a response to it, but I'm not inclined to support paying the bill.
I'll make a motion to approve the payment of the bill in the amount of, it's $3,300 total. There's 2 invoices that were attached to it.
I'll second.
Further discussion? Roll call vote, please.
Supervisor Bansky?
Yes.
Supervisor Laska?
Yes.
Supervisor Fisher?
No.
Supervisor Wolf?
Yes.
Chairman Merrick?
No.
Motion approved.